Good evening, everyone, and welcome to our next episode of webinar on IBC. And thanks for your time. And this time again, we have Amit Gupta, my good friend, who is CS and IP both and known to everyone. And to brief, the topic is only the proposed changes in IBC code. Though the suggestion date is over, but at least we can discuss what is proposed changes. So we can say a little bit late in discussing, but still since these changes are coming, we should know the thing. So today we have one of the very well-known and knowledgeable, my friend and IP and participant with us, Amit Gupta. And to introduce Amit Gupta, his profile is too big, but just to say that he is a fellow member of ICSI, our institute, and also is IP. And he is in practice for last 22 years in corporate and allied law. And he's a regular speaker. He's a science and law graduate and diploma holder in banking and finance from ICFI. His position he hold with ICSI, member of North India Regional Council, ex-officio member of Managing Committee of Lucknow Chapter, and Lucknow Chapter of NIRC Managing Committee, Chairman of Research Publication of NIRC, member of Secretarial Standard Board, member of Auditing Standard Board, member of Core Group of Vision 22 of ICSI, Task Force, member of Task Force of Corporate Law for 2015 to 18, Chairman of Core Group on Corporate Law Publication. So many are there, Amit. I'm not telling that too much because member of Corporate Law and Corporate Governance Committee, PhD Chamber, member of National Council of SOCM Merger Acquisition, member of Law Justice Committee, PhD member, and he has contributed in publication of ICSI Premier on Company Law, Voluntary Liquidation, Handbook on friends, Voluntary Liquidation, his book is really master blaster. One should refer that. Handbook on Interim Resolution Professional, FAQ on Section 8 companies, guidance note on secretarial audit, referencer on pre-certification of e-form, backgrounder on National Company Law Tribunal, model governance code of meeting of Gram Panchayat. He was other contributor in Vision, new ICSI 22, compliance management audit configurator, new syllabus of our executive professional program, study material for the same. He is a visiting and guest faculty of various management professional institutes and regular speaker at MSOP, DP seminars, conference organized by ICSI, ICI, AWI, and Chamber of Commerce, University, and Management Institution. So friends, such a long profile of Amit, very well versed, very well read, and very educated. So Amit, one thing that our book on voluntary liquidation, I think with the new amendment, I already suggested to ICSI IPA that it should be again published. Yeah, and that will be really helpful to all IPs because that's the only complete book of voluntary liquidation available.
Yeah, that was first and the only complete. I think there is no other publication available from any IPA also. Neither private sector nor public sector. Surely, I think it's a time when a lot of case studies are also there. I think we should definitely, and we may even plan one particular session on voluntary liquidation itself, because there are a lot of case studies which had evolved in the past 6 years of evolution of insolvency. I think that's a very good topic to do with. Let us.
I think with ICSI, IBBA, we should work it out. And also I have, of course, everyone will agree, there should be secretarial standard for the COC, though it is drafted, but at least not in a voting rights or anything, but administrative behavior and all that can be there, will be there.
Absolutely, we had been to the extent possible. We have been following also, but to make it binding force, I think suggestion is valid. I am in sync with the same, though it may require certain tweaking in the application of secretarial standard as it is to modify, suitably adopt for the...
No, we have to modify. We have to carve out separately for this.
Yes, yes, yes.
Okay. With this, now I think Amit, you can say a few words on the topic, and then Jasveen can start the presentation.
No, I think we will go other way. Let us have a hearing to Jasveen. She has done a wonderful job. I was just glancing through the presentation. So we'll have a brief overview, and by that time we'll also consume. There will be some discussion point, and let us then open the floor for discussion. Me and you will try to understand what all are the in the kitties of the insolvency law. Though the changes are very laudable, I'll say this much. I personally don't agree with many of the changes. I'll share my views also, because too many changes are in a way, though law is dynamic and should be dynamic initially in the time where we are, but too much changes are destroying the basic essence of resolution, and everybody is now feeling like there has to be some stability in terms of basic framework in which we have to operate. And this new changes what have been proposed are again making many U-turns. I don't know where we will lead to, but anyways, we will discuss, I think.
Okay, then Jasveen, start.
Sure, sir. Sure. I will just share my screen.
Yeah.
We'll just dive into the amendments directly, since, like Sir said, they're very dynamic and extensive in nature. So the proposed amendments to IBC pursuant to the MCA notice dated January 18, 2023. The proposed amendments have 5 major areas of amendments that have been proposed. First is in the area of use of technology in the IBC ecosystem. Second relates to admission of CIRP applications. Third is streamlining the insolvency resolution process. Fourth is in the area of recasting the liquidation process. And the last relates to role of service providers and other stakeholders. There are multiple amendments, proposed amendments in each of these topics, which we shall discuss here on. First, use of technology in the IBC ecosystem. So as on date, we have separate technological platforms for MCA, NCLTs, IBPI, information utilities, and other service providers and basic pillars of IBC. With these proposed amendments, they wish to improve the integration between these technological platforms, and which would lead to transparency, maximizing the output and minimizing the delays caused in the process, and to facilitate an effective decision making. Second, they also intend to provide an e-platform for case management system, automated processes to file applications with the adjudicating authorities, delivery of notices, enabling interaction and integration with the entire ecosystem, wherein the IP will interact with the stakeholders, which can be the creditors, government authorities, etc. Storage of records of the corporate debtor in a centralized system, and to incentivize participation of other market participants, market players in the IBC domain. This is to consolidate all the information and simplify the process. Second is in the area of admission of CIRP application. The first is to increase the reliance on the records submitted with information utility during the admission process. As on date, only financial creditors are obligated to compulsorily submit the financial information with information utilities. It is voluntary for operational creditors as of now. However, what they propose is to amend section 215 to provide that the operational creditor that intends to apply to the adjudicating authority for initiating CIRP against corporate debtor would be obligated and required to file the information, relevant financial information with the information utility prior to submission of such application. They've also provided that there would be a reasonable opportunity given to the corporate debtor to respond to such information that has been submitted by the operational creditor, and this information would be treated to be authenticated if the corporate debtor does not respond to the same within a stipulated time period that would be provided by law. The intention behind this is to save judicial time, the time spent by the adjudicating authority to determine the test of default, as well as to increase the role and responsibility of the information utilities. Other set of amendments relating to information utilities is the adjudicating authority would rely only on the record of default that is available with the information utility, and it shall be treated to be a conclusive proof of occurrence of default. Only limited number of cases, the adjudicating authority on genuine grounds and reasons that are proven may consider other evidence. So this automatically increases a reliance on the information utility and the data available with them. Amit, so your inputs on this, or Dipti ma'am, your inputs on this?
Yeah, Jasveen, if I can just interject on this particular point. So to say whether it is going to be proving anyway useful or not useful, because we have already seen that in case of the financial creditor, this particular provision has already been there. And if I recall correctly, in May 2020, the NCLT president came out with the circular also saying that now record of default from the information utility shall be mandatory for the admission of financial creditor cases.
Right.
However, because there was no legal backup, because the Insolvency and Bankruptcy Code as well as rules made thereunder were not having any mandatory requirement. So the president has to ultimately withdraw that notification, and it was again made optional, though section 215 was very categoric and is very categoric in the nature that the financial creditors are under an obligation that they have to create this information in the information utility. There is no option available. And good part is that although initially it was not there, initially the law was like the financial creditor will send the information to the information utility, and as and when the corporate debtor will be confirming to the same, the record will be taken by the information utility. And similar situation was provided for the default cases also. So today, let us say the State Bank of India is releasing a credit facility of rupees 100 crore to ABC Limited. So State Bank of India was obligated to send this information of lending along with the required data inputs, whatever this IU provides, asks for, and the information utility, that is National E-Governance Services Limited, will in turn ask the corporate debtor to verify the genuineness of the information what has been submitted by the State Bank of India.
Right.
So one reminder will be sent, second reminder will be sent, third reminder will be sent. Now, law is that if after even third reminder, the corporate debtor does not respond, then it is considered as a deemed acceptance. So that means the National E-Governance Services will record that as a lending of the credit facility without any confusion. Same thing happens now with the default also. Now, if ABC Limited goes into default, what will happen? ABC, State Bank of India, will again initiate the process and will inform to the National E-Governance Services Limited that ABC Limited has defaulted in the payment of so-and-so installment. Again, very naturally, when the information will pass on from any National E-Governance Services Limited to the respective concerned corporate debtor, that is ABC Limited, again ABC Limited is not going to accept it readily. In majority of the cases that default has occurred, they will try to dispute. So, or maybe they will not respond at all. That is the safest thing. So again, the law was amended way back in 2018 itself, where the provision was made that again 3 intimations will be sent with a particular time gap. And even if after these intimations, the response is not coming, then it will be again a deemed acceptance. So the deemed default will be recorded in the information utility, and that record of default will be considered as evidence before the adjudicating authority. So this provision is already there in existence. Maybe it is not yet mandatory. I don't know, means it is yet to test the water, because in the cases even where the record of default has been there from the information utility, the adjudicating authority is not placing much of the reliance on these record of default, and the matter is still continuing before the adjudicating authority. Now the real problem, because this is a situation as on date in respect of the financial creditor, I believe the change that is likely to happen in case of the financial creditor is only one, that law will made it mandatory that this record of default will become now essential component of each and every application filed by the financial creditor. So this will become mandatory in application whatever the financial creditor is filing for initiating the CIRP process. That is one change that I am expecting. Now, second change, which is rather larger in respect of the operational creditor, because for operational creditor, presently this law is optional. It is not mandatory that you have to initiate the process of informing to the information utility in respect of either supply of goods or services or default thereof.
Right.
Now, intention is very laudable. I'll not say intention is not very laudable, because the primary problem of this entire insolvency law, as I understand, is that the adjudicating authorities are overburdened. They are not having sufficient bandwidth to deal with the number of cases what are being filed in the respective of the adjudicating authorities. And reason is because number of cases, number of the multiple jurisdictions with regard to the company law matter, with regard to the insolvency matter, with regard to the other matters also. So that multiplicates the problem. So instead of finding out a right solution, perhaps what government is trying to do is trying to create another forum of litigation. Because what will happen now? Now, if I am saying that government is relying more on the information utility in terms of burdening them with the responsibility that now you will be information collecting agency as well as the primary agency for deciding whether the default has happened or not.
Right.
So they will be even doing a correspondences with the corporate debtor and the operational creditor in terms of establishing the requirement of further evidences and the documents to establish whether the default has taken place or not. A, they are not judicial authority. B, I don't know their competency also in terms of understanding this entire process of establishment of default. So I'm having my own doubts with regard to any success coming particularly from this. Rather, I see that a lot of litigation will increase at the first stage itself, where the operational creditor decides to move towards filing the CIRP. Because what the law says, if today, let us say, I had supplied goods of 1 crore rupees to the corporate debtor, right? Today, I have not supplied with the intention that tomorrow I will not be getting the money back. I had supplied with all fair intentions that in due course, I am getting past 5 years payment. I will get this payment also. Now, 2 years later, or maybe 1 year later, when I had used all my resources and the payment is not coming forward, then if I intend to initiate the CIRP, law says that then in that case, before initiating CIRP, you will be obligated to create a record of default in the information utility. So first of all, I have to wait for the period. Rather, it is not mandatory that I have to wait, but any sane person will not go for creating the record in the information utility unless and until it is obligatory on his part, right? Even financial creditors are not doing right now in many of the cases, though it is mandatory because utility is not there. So information utility, how many operational creditor will use that itself is a big question mark. And I'm saying tomorrow when the default, when I'm on the verge of filing the application, so what I'll do first, should I shoot the demand notice first or should I go to information utility to create a record? The moment I create a record, moment I go to create a record in the information utility, the message will go from information utility to the corporate debtor. He is going to get an alert that something wrong is going to happen against me. He will initially, whatever he has not done up till now, that is the opportunity to create the dispute. Because your dispute has to be prior to the demand notice. You have not issued the demand notice till date and you have triggered the matter with the information utility. So you are giving an opportunity to the corporate debtor to have one more opportunity where he can raise the dispute. The moment he raises the dispute, then you are gone, where whether you have a case of default or not before the information utility, ultimately, at least I as a reasonable professional, I'm not able to understand how the sequencing will happen. Unless and until today I supply the goods of 1 crore and the moment I supply the goods, I immediately inform to the information utility that on the credit of 30 days, I have supplied goods rupees 1 crore. And the moment I receive the payment, I again inform to the information utility, either the chapter is closed or the default has occurred.
Right.
Then though it makes sense. But if I am triggering this event or I'm deferring this event till the time of making a decision of going to the insolvency process, I'm having my own doubt that it will lead to any success. It will lead only to litigation. We can have the view of Dipti ma'am also, but my personal view is that it will add to a lot of litigation and it will be proving adverse against the interest of the operational creditor also.
Thanks, Amit. What I think that first of all, we have to create awareness among OC, that there is an information utility and this kind of facility is available. In India, how many OC are knowing this facility? That is a main area of concern. Forget about next stage. Because first of all, we should make aware this kind of facility available, the process available, advantage available. If you understand the new system like mutual fund investment, how much SEBI has marketed and see today they have reached. So FC being a banker majority and they are in a very systematic regulated market, the implementation still it took time. So when we say OC are scattered all over India and also out of India. Now, if we make this prerequisite, then the knowledge of the same and doing the same and the process, everything should be known to each and every participant of this process. Because OC can be anywhere in the world for initiating insolvency in India. So again, in cross-border insolvency and all that, we have to again check all that. So that is another point we have to keep in mind. And of course,
very important point, just to add one very small point, the point that you have raised, that creating the awareness, I believe, yes, it is very important. But the challenge, I believe, in creating the awareness is also the cost involved. Yes. The government has to come forward and maybe either minimize the fees or maybe for the operational creditor, it should be either free of cost, because you are just creating the information, right? You are not supposed to create a financial model for your own survival. For survival, I think financial creditor, lending institution are already there. So now, if operational creditor has to bear some money, even if I am say aware today that I have this facility, when I know no, if I'm supplying goods to ABC Limited and ABC has a reasonable good track record, my money will come. Why at all I should be bothered to register with NESL? I am not going to be interested unless and until it is going to be a damn cheap price as far as the money is concerned, considering the huge volume. As you are saying, the OC's market is multi-time more than what the financial creditor market is, right? So if you rationalize the cost, I think there is a possibility what you are saying, that a lot of awareness will be created and people will, this benefit will come. As again I am repeating, the benefit will come only on the moment you supply the goods or the transaction has created, you are registering with the information utility. If you take it or if you defer it to the later stage, you are gone. My view is that you are not going to be successful in your insolvency process. You may have a challenges with regard to the likely possibility of triggering a dispute, as we have seen that we have many cases where for the last 4 years, 5 years, we are still fighting before the adjudicating authority on the ground of dispute itself. So objective, I can say, so I'll just take a minute more. The objective of the insolvency bankruptcy board by giving this paper and giving this, considering this suggestion, was only that perhaps they can reduce the burden of adjudicating authority by at least becoming a collating agency of all kind of records, at least in the information utility. So they can have the all record and they can call the information utility to produce all these records before the adjudicating authority, so that they are not struggling with the documents at the time when the adjudicating authority wants to decide the matter. I think that is the limited objective. They are also aware perhaps that how many success stories will be converted from this particular change. But yes, if objective is limited to that, yes, to some extent, but the fundamental question that I raised in the beginning as to the timing and other thing, that again needs to be addressed, or at least we need to understand. At least I need to understand. Please.
I think the move is good, that they want to reduce the dispute. Only thing, the implementation, and I think government must have also thought, and they will also come out. They also. So let's see. Every new change has its teething problem. Yeah, Jasveen.
Yeah.
Please go ahead.
Thank you, sir, ma'am. I'll just go ahead with the next amendment. Mandatory to admit an application under Section 7 where occurrence of default is established. Sections as on date, Section 7 subsection 5 states that the adjudicating authority may admit an application if it is satisfied that there is occurrence of default. The Supreme Court, Honorable Supreme Court, in the judgment of Vidarbha Industries Power Limited versus Axis Bank Limited, has interpreted this word, the use of the word may, and has held that the adjudicating authority has a discretion to admit or reject the application despite the existence of default. To overrule this decision, it is being proposed that Section 7 should clarify that the adjudicating authority is only required to be satisfied about the occurrence of default and the procedural requirements, and is not required to investigate further into anything else. And where a default is established, it will be mandatory for the adjudicating authority to then admit the application and initiate CIRP in a Section 7 application. Further, Section 7 subsection 4 provides that an adjudicating authority shall have the time period of 14 days to ascertain the existence of default. However, they have proposed to change this to mention that the time period of 14 days will be provided to the adjudicating authority to decide whether or not to admit or reject the application, and not just for ascertaining the default. This is to align the provisions with the original intention of the legislature.
So, I think the move is laudable and is a counter reaction to the Vidarbha judgment, which was unsettling the position that got settled over the period of last 5.5 years of insolvency law evolution. So I think a move in a right direction, whatever disturbance was created or deviation rather was created by Vidarbha judgment or attempted to be created, because maybe in that particular matter there were a peculiar circumstances, but quoting unquoting that particular judgment, we have seen a lot of litigation coming up before the adjudicating authority since the inception of that judgment, and every now and then applications are being filed with regard to the various extraneous reasons and the factors due to which the CIRP admission was deferred or was not to be considered by the adjudicating authority. And adjudicating authorities were also right because of the Vidarbha judgment that they were bound to consider the other factors also, right?
Yes.
So I think as far as the first part is concerned, where they are giving this clarification sort of that this will be on a par with the operational creator section, that is section 9, where the word shall was used instead of word may as is used in section 7. So now they will be putting both of the provisions at a par, and it will be mandatory on the part of the adjudicating authority once the default is established to admit the application for the CIRP process. Now the second part which is very interesting is in some of the arguments it was taken that 14 days time has been only for the purpose of deciding whether the default has been there or not. It is not for admitting. So the regulator has thought to remove that discrepancy also, that 14 days timeline spirit is that this timeline is for admission or rejection of the application. So accordingly this amendment will also. So we appreciate the initiative of government that they have tried to bridge both of the gaps wherever the possible litigation was increasing day by day on account of Vidarbha and on account of this particular interpretation also. So a welcome move indeed.
Right, thank you, sir. Restricting the right of the promoters to propose an IRP under section 10, where the corporate debtor itself initiates CIRP. There is a provision that states that the corporate applicant shall propose the professional to be appointed as the IRP. Now they have proposed to amend this provision to delete the right and omit the right of the corporate debtor to propose an IRP. In such cases, IRP shall be appointed by the adjudicating authority from the panel as provided by the IBPI. This is to ensure an independent professional and a person is appointed, and there is no scope of connivance between the IRP and the corporate debtor and its management.
You want me to comment? Should I?
Sure, please go ahead.
I don't know, means the clarification, although I don't have any reservation as far as the proposal is concerned. They want to take away the right of the corporate debtor to propose the IRP. That's their choice, but the rationale that they have given, perhaps I'm not very happy with the wordings what had been mentioned in the justification, and it looks like the people who are appointed as a interim resolution professional or proposed as a IRP are acting in a connivance with the corporate debtor, or maybe if the matter is for financial creditor, so in that case also, if some financial creditor is filing an application is proposing the name of a particular IRP, so he is acting in connivance with the financial creditor. It looks little bad in the taste. I don't appreciate the taste in which this amendment is being proposed, that the independence is not there, which is just because there are certain bad fishes in the market, you can't blame the community at a large, right? So I personally feel that such kind of statements or such kind of logics should be avoided in the discussion paper, particularly when we are trying to give the impression that the independence to maintain the independence. So it looks like that government is trying to say that when somebody is proposing the name of IRP, then the independence is not there. Whereas the basic on which this entire insolvency process is established, and IRP is considered to be one of the one of the 4 pillars on which the insolvency law is based on. And I am saying that no, this pillar is little weak because this might not be independent. I think we are doing injustice not only with the entire process, because the larger process is in respect of the financial creditor. And in that case, I am saying no, because there is the possibility that there may be a connivance. So what about the FC cases? If CD can be in connivance with the IRP, then what about the financial creditor? Is he not, or can he not be in connivance with the IRP? As the lawmaker want to make the law, I don't have any problem, because in case of OC, there is a option whether you want to propose or not. And in case of CD, they want that in these cases, the right to appoint the IRP should be vested with the adjudicating authority, which is again a matter of discussion and debate. In many of the cases, the success stories or the past experiences suggest this has not been very congenial and very good move as far as this option of appointing IRP through the IBBI or the adjudicating authority process is concerned. But I'm not commenting on that, because that's a choice available to the lawmakers to do so. I'm okay with that, that they take away the right of CD, but justification, I'm little not very happy with the justification part. Please go ahead, or maybe Dipti ma'am if has something.
No, you go ahead.
Okay,
Yeah.
I'll just go ahead. Empowering the adjudicating authority to impose penalties for violations. So section 235A provides punishment where no specific penalty or punishment is being provided under the code, wherein it states that such an offense can be punishable with a fine of not less than 1 lakh rupees and may extend to 2 crores. So that is the position of law as on date. Now they have proposed to empower the adjudicating authority to impose these penalties under section 235A, and the proceeding shall be carried out on an application made by IBBI or any other person authorized in this regard. They've proposed that the minimum penalty imposed by the adjudicating authority should be not less than rupees 1 lakh per day, and it may extend to 3 times of the loss caused or the unlawful gain that is derived by the person, whichever is higher. This is to link the amount of penalty with the loss caused or the gain that is being made. They've also said in the paper that in the notice that the non-cooperation by promoters can also be penalized under section 235A.
And not only that, 235A is one part. Non-cooperation can also be a bar under 29A.
We're just coming to that, sir. We're just coming to that in the next slide.
That is another danger. So to comment on the provision of 235A, I personally feel is a welcome move, with only one suggestion which I have given to IBBI also when the due date, I think 7th of February was there. Now, my view is that as far as the decriminalization process is concerned, and in decriminalization process, because presently let us understand what is the process. The 235A will require the filing of case before the special court,
right,
constituted under the Companies Act, right? So it is a criminal process, and you will be tried before the court of law by following the CRPC process. Evidences will be there, and your witnesses will be there, and after that you will be either acquitted or convicted, or you will be set free, right? So government is saying ki, no, if the offense is not very heinous, then when we are committed that we will decriminalize all these offenses which are not very serious in nature. So we are decriminalizing this particular provision also, and all these offenses which are less heinous in nature, they will be civil offense, and the adjudicating authority will have a power to levy penalty. My only suggestion or request is that this minimum amount of 1 lakh per day seems to be little on the higher side. It is not justifiable, because we have seen the provision or the harshness of these provisions, particularly in section 42 of the Companies Act, where the adjudicating authority, which is the registrar of companies in many of the jurisdictions, have levied a penalty to the tune of 1 crore, 1.5 crore on the premise that I don't have a power to reduce the quantum of penalty. So either adjudicating authority should be vested with the power to decide the amount on case basis. 1 lakh rupees may be the quantum up to which they can levy the amount, and the discretion is given to the adjudicating authority to decide the quantum. If quantum is not decided by the adjudicating authority and it is decided by the law that it will be minimum 1 lakh rupees, then I think it is going to be little harsh, because the process what is being followed in the criminal trial is not being followed here in the civil trial. In the adjudicating process, we are only doing a summary proceeding, and in summary proceeding you may not be doing the witnessing, or you may not be doing the evidences, right? Without that, you are levying the penalty and saying that previous also the fine was 1 lakh rupees. On the same line, I am just proposing taking away the imprisonment or the other penalties provision. I am now equating it with the penalty. So the criminality part will go away, and the adjudicating authority will levy the penalty up to rupees minimum 1 lakh rupees. So discretion should come. That's my only suggestion. Otherwise, my thought is that it may be little harsh to the professionals as well as to the other people. Maybe if a fraud case is there, you levy 1 crore also per day is okay. I don't mind. But in those cases where the adjudicating authority also agrees that yes, default is or grievance is little less, but I am bound by the law, I cannot help you. You have to go to the higher court only for the purpose of reducing the amount of penalty, as we have been seeing in the case of RD orders. In the appeal matter, we are getting the reduced penalty, but otherwise we don't have an option.
Right. Further, they have said that the adjudicating authority would now be empowered to impose penalty in case of any frivolous application. This was only limited to admission proceedings as on date. Now they want to desire to extend it to any application. Then, as Sir rightly said, they wish to empower the adjudicating authority to bar promoters from being resolution applicants in CIRP based on their conduct of the promoter during the CIRP and contraventions committed by them. This is again to prevent non-cooperation by the management.
Yeah, I would like view of Dipti ma'am on this 29A.
Actually, it is telling that 29A empowered to bar promoter from being resolution applicant and CD based on conduct of promoter during CRP.
So one more condition they will add in 29A.
Right.
They will say
that
the adjudicating authority has barred you from being a resolution applicant, then you are barred. Now,
I know, and that they are telling section 19, non-cooperation and all that. Now, in that case, section 19 application should be decided first so that they become ineligible for filing resolution plan. That will be the situation.
Yeah, correct.
Now, see the situation. If I say that,
not only, ma'am, in one matter, let us say I am a CD in respect of one of the company, and I am a promoter of that CD, which is undergoing the CIRP process, right? And in that matter, maybe there was a non-cooperation. So I'll be barred for the other entities also from becoming a resolution applicant. It is not that I'm barred from this entity. Let me put the perspective with which I want to make a discussion. See, originally 29A was not there in the BLRC recommendation. 29A got inserted through a parachute entry when the government thought that either maybe the provisions are being misused, or the insolvency mechanism is being misused, or there is a possibility of being misused. This was an impression that there has to be some eligibility criteria. Basis that 29A was landed in the insolvency law. Now, this is one part. There are certain entities which are belonging to special cadre, which are called micro, small, medium enterprises. Part of the barrings or limitations under the 29A have been carved out against them, and they are not considered ineligible. The majority one being the NPA account provision and the guarantee provision, right? Which are more dangerous, most dangerous. Those provisions have been kept out. Now, this is second set of company. Now, third set of company which we are now saying and then there is the PIRP model where the if you are a micro, small, medium enterprises, then again you are not barred in participating these processes again, right? And we have seen the increasing number of resolution, increasing number of liquidation matters in comparison to resolution over a period of time. And we understand the challenges also in backdrop in which the companies are going consistently to the liquidation instead of resolution. There are many factors, but I am saying, yes, this is also one of the factors, because the person who promoted the entity, he himself is not getting opportunity to revive that entity. I'm not in favor of the fraudulent people who are taking away the money and siphoning and running out, and they are again trying to buy back the asset at a lesser cost. I'm not in favor. I'm not advocating for them. I'm only trying to place a picture that we need to balance the law in a manner that it is conducive to the growth and the objective for which the insolvency law was initiated. Was the insolvency law created to create such kind of barrings to do the business, or to see the fundamental premise on which the law was evolved was that no business should be shuttered down only because there is a cash flow problem. Insolvency is a cash flow problem, that my entity, business entity, is not able to generate the cash today, and maybe due to inefficiency in the management, maybe due to business technology failure, maybe due to any XYZ reason. So maybe the new management may come, or the other solutions may come, and the business should continue. Now, if business continuance is hampered on account of 29A barring, I think we need to reconsider that whether such kind of barrings should be there or not. Having said so, I am again repeating that I am not in favor of the people who are fraudsters, who have done siphoning of the money. So we need, in insolvency law, somewhere create a fine distinction between the fraud and the business risk. Wherever there is the fraud, of course, 100% barring should be there. There is no second thought on that. And those people should be completely ineligible for coming into business again through this particular entry. Now, if a person is not a fraudster, if I have just taken a business risk and I have failed in the business, why at all I should be disallowed? Because in India, it is largely 90% businesses are family owned. 90% businesses are clustered, where only one family or two families are involved, and they are promoter driven businesses. So in majority of the cases, you will lack the systems, you will lack the processes. There are no standard templates available. If a person X is not sitting on the table, you cannot move an inch in the organization. So that's the reason that there are no buyers of these particular assets. And the companies, when they crumble, there are no buyers available in the market. So that's my limited point. I'm not against this particular new category of people, but I'm only worried that tomorrow this new breed may be created to misuse the system against these particular people. That look, you are not on pretext that if you don't cooperate me, then you will be barred permanently from being a resolution applicant. This maybe on one hand only to threaten to some extent, I'm okay, But as ma'am was rightly mentioning, for this 19.2 application has to be decided. I don't know whether it is only 19.2 or on what basis the adjudicating authority will have the understanding. I am not very sure. But yes, 19, one trigger.
Yeah, it is one trigger. And if you say that conduct of promoter during CRP and contravention committed. So I think what they are trying to see that if during the process, it is understood that promoter was subject to and has carried out so many contravention and his conduct, I think they are keeping liberty. It's not that blindly they are doing. It will be subjective if they find that it is not the right person and all that. What you are talking about, fraud and all that kind of thing. In addition to fraud also, because many times it is not fraud, you can't establish that as a fraud. Then it becomes difficult. So they want to keep some option open to adjudicating authority where they feel that this person are not fit to do the business, they should be debarred. I think it can be said it's a right way that there some leverage is given to the adjudicating authority, though subjective, but it will help them to where this kind of case is established, they can do this. But it will be subjective, as you rightly said.
Right.
Yeah, Jasveen, go ahead.
The second category is streamlining the insolvency resolution process. I'll just go a little faster due to the time constraint, but feel free to interject me, sir, whenever you feel, give your inputs. Rethinking the fast track insolvency. As on now, there is only a subtle difference between the timelines between fast track insolvency and CIRP. And there is a proper application that has to be filed before the adjudicating authority for initiating the fast track insolvency. Now they propose to make fast track insolvency a more informal and out of court process, where they've stated that the unrelated financial creditors shall be given the option to approve a resolution plan, and thereafter for the final approval it should be placed before the adjudicating authority. They've proposed to introduce certain checks and balances to be included, wherein they state that the application for approval of the plan should be approved by 66% of the unrelated financial creditors. Thereafter, they've stated that the financial creditors shall be the one that will be responsible for overseeing the process and to appoint an insolvency professional to manage the fast track insolvency. Further, they've provided an option to the financial creditors to approach the adjudicating authority to seek moratorium in case of fast track insolvency. This is to ensure that the fast track insolvency actually becomes a very fast process and an informal and out of court kind of a process.
Now, Jasveen, have you any data with regard to how many fast track insolvency processes have been undergoing or have completed?
None to my notice, sir. As per my knowledge, none of them.
Dipti, ma'am? So my point.
I don't have idea actually.
So that is why I was saying I don't know where we are putting our energy. We are putting so much of energy in the areas where perhaps we don't require any intervention. Even if we do unsettling the things what are going on, I per se I don't think that there is a need of fast track insolvency process at all. I'll tell many reasons why. Because the person who is the operational creditor or the financial creditor at the time of filing application should make a demarcation that this entity qualifies in the parameter fixed by section 55(2) of the IBC Code, right? Then they have to categorize that this will be a fast track insolvency resolution process. Right. Then only you are given the advantage too. Otherwise, you are not given that benefit of fast track insolvency process, right? Now, another danger that you initiated the application under fast track. Later on, it was discovered that the value of asset is beyond the limit prescribed under 55(2). Now, what will happen? You will move the application for shifting the application from fast track to the normal CIRP process. right? So all this is going to add a litigation only or delay the entire process rather than completing the process.
Right.
Then in CIRP process, we know howsoever squeezing we are able to do, but still we are not able to complete the process in 330 days. Here we are saying the process will be completed in 90 days of time. Now, even if you are leaving it to the discretion of the adjudicating authority or to the financial creditor to decide whether the moratorium has to be there or not to be there, I think some of the financial creditor who have a majority stake, they may misuse this provision to the best of their advantage, that they may not invoke the moratorium and they may continue the SARFAESI proceeding, they may continue the other realization proceeding to the disadvantage to the other creditor. My point is that let us keep the law straight and simple with least number of deviations or permutation and combination. There was no, I still feel that there is no need with the having a fast track process at all, because I have not seen, maybe I'm ignorant, but I have tried to find out the cases. There are few cases, 2-3 cases I have found after this discussion paper, only just out of curiosity I have tried to search, but I have not seen what the result has concluded, whether they have concluded as a or they have been withdrawn. So on less important things we are putting more attention, it looks like.
Right. Thank you, sir. Next is expanding the applicability of prepackaged insolvency. Prepackaged insolvency, as we all know, is applicable only for corporate debtors that are classified as MSMEs. Now they intend to expand the scope of prepackaged insolvency to prescribe categories of corporate debtors in addition to MSMEs as well. They shall provide relevant rules in that regard if this sails through. Further, they have tried to simplify or suggest ways in which the prepackaged insolvency can be simplified, wherein the threshold for the approval of financial creditors for initiating prepackaged insolvency is proposed to be lowered from 66% to 51%. They've also suggested that the requirement of declaration being given by the management of the corporate debtor regarding avoidance transaction and fraudulent transactions can be eliminated with. Further, they're proposing to omit the provisions related to change in the management pursuant to Section 54J in case of fraud, or conversion of PPIRP to CIRP or liquidation. This is the reason for that is so that the management does not have the fear of changing change of hands of the management. Further, they've also stated as a safeguard, the COC shall always have a discretion to terminate the prepackaged insolvency process at any stage where they discover a fraud or an irregular activity by the management.
So Jasveen, now here is another deviation point to be the takeaway that we want to, in respect of 29A, I wanted to create. This is another deviation. So if I am opting for PPIRP, up till now it was, let us say, restricted only to MSMEs. Now it is going to be extended to the other corporates also. And I believe the way PPIRP was designed, the 29A restrictions are not applicable on these particular cases also.
Yes.
Now, in this particular case also, these category of peoples will again be in exempted category from 29A requirement. So this, again, this is just a side point. I just wanted to flash because we had a just now discussion. Welcome move that we are trying to extend the PPIRP model to the other model. This I have been advocating right from the 2021 when this provision was brought into force after this COVID pandemic. Though this law has this particular scheme has not taken any success story so far, primarily because of, I believe, 54C3, which was regarding the obligation on the CD to furnish a declaration regarding the avoidance transaction and the fraudulent transaction. Nobody was ready to take that risk. Tomorrow, God forbid, if some transaction is detected because when you do business, you may have erred and something wrong might have happened. So nobody was coming forward in giving such kind of declaration. So welcome move that they have now woken up and removed that requirement. And as far as the possibility of converting PPIRP into CIRP and to liquidation, that has also been removed from the law books. So that also will give a comfort that by PPIRP is just a option which you want to test. If it is successful, then the resolution will happen. If it is not successful, at least there is no harm or no risk which is going to come forward. So it is an option. As an option, if I see, so it is definitely I'll say a good option available to the market. How market will react will depend which all categories we are trying to add in addition to MSMEs, because alone MSMEs were not very interested in coming forward to this particular settlement for two reasons. One, if I am a banker and you are a corporate debtor, if me and you, where multiple peoples are not there, let us understand PPIRP was to be successful in those cases where there are multiple financial creditors, right? Only one financial creditor is not able to arrive at a resolution. If I am having only single financial creditor with whom I have to make a scheme, why at all I need a PPIRP model to make it successful? I'll go to bank, I'll just make a OTS and I will sign the document and I'm done. I need not follow this cumbersome process where there are multiple people involved, multiple financial creditor involved. Now, good that they have reduced the even limit also from 66% to 51% to arrive at a consensus, which is again, I believe a good move if at all we want to press, but how the interest of the minority stakeholder in the FC voting will be protected, that needs to be looked into. But prima facie, it looks very promising. Only challenge that I can see is in those cases where you have a single creditor. I don't see any incentive coming forward to those people just by getting the scheme recognized and registered by the adjudicating authority, how much advantage they are getting. Unless and until stakeholders are many, I don't see that there will be many takers.
Right. Improving outcomes in real estate cases, the most discussed topic after this notice had become public. There is no separate procedure as on date for corporate debtors dealing in real estate sector. So what this notice proposes to amend is, if an application is filed to initiate CIRP against a corporate debtor that is dealing in real estate, and the default pertains to one or more real estate project of that corporate debtor, then the adjudicating authority shall have a discretion to apply for the CIRP only in respect of those particular projects which have defaulted. However, while making such decision, the adjudicating authority shall consider the concerns of all the stakeholders and the defaults made by the corporate debtor before coming to such a conclusion. The justification for this is the peculiarity in the real estate sector as regards, and they did not want the corporate debtor to be affected as a whole just due to a default in a particular project. Further, they had stated that section 28 may be amended to allow the resolution professional to transfer ownership and possession of the plot, apartment or building, as the case may be, to the real estate allottees with the prior approval of the committee of creditors. It has been seen that the real estate allottees have been categorized as financial creditors. However, their interest is not in the repayment, but in taking possession and ownership of these plot, apartment or buildings that they had been allotted. So, which is why they have proposed this amendment.
So my views on the real estate sector are very, very different. I am not in favor of real estate companies to be in the radar of insolvency at all. When there was a separate law which was enacted in the name of RERA.
No.
Why not government is giving enough teeth to the RERA to deal with the problems of the real estate and the home buyers? Why insolvency law was amended to categorize the peoples who are not financial creditor as a financial creditor in the garb of you can say the reason that there was no other appropriate forum from where these disputes could be sorted out, right? It is inefficiency of one particular regulator or the government that this particular forum is being burdened with the real estate cases. And that is the reason, if you see the number of cases which are undergoing through the insolvency, I believe not less than 40% of the cases are belonging to the real estate.
Absolutely.
So if you declutter the insolvency with the real estate cases, I think 60-70% of your problem of cluttering of insolvency of your adjudicating authority will automatically be over. So you can solve this problem, but I believe we are trying to create more problem with the reverse insolvency being in vogue. I think we have already 3 cases. 2020 was the first case when the reverse insolvency was admitted. I don't know how it has taken a shape, but I believe the government has the intent and willingness. That's how the adjudicating authority, rather appellate authority, has recognized the concept of reverse insolvency way back in 2020. And as late as in the Ansal API matter, again, they have affirmed the decision. And now it is coming up in the shape of a discussion paper where they have intended to recognize it as a law, that reverse insolvency is going to be a law. So my view, if somebody asks, then I'll say, per se, see, we are just lured by one fact and one particular aspect, what we have witnessed in one particular case or in 2 particular cases, right? There may be many more varieties which are going to come on the table. I'm not disputing that reverse insolvency is certainly a very good option in a case of a real estate, right? But the amount of challenges you are going to witness, because today law is not there of reverse insolvency. It is only on the appeal of the adjudicating authority. The NCLAT has been recognizing the concept of reverse insolvency. The moment it will become the part of your law books, every now and then the applications will be moved for the reverse insolvency only. And what kind of misutilization of resources would be done? Because in case of reverse insolvency, what the law is, so let us say Ansal has got some 10 projects, and only in respect of one project somebody has done a default, and group of investors of that particular project may initiate an insolvency against that very project only. Now it is not a separate legal entity. The project is not a separate legal entity. Project is just a project, just because of the fact that RERA recognizes that all money in a real estate project for a particular project will come and will be allocated in a separate bank account, right? Are we saying that all corporates are maintaining those Chinese wall to do all those expenses and maintain those accounts? The possibilities of defaults and the possibilities of fraud may be multi-fold increased. So my view, if somebody asks, I am not in favor of reverse insolvency at all. And my view is that real estate, all entire cases of real estate should be out, and RERA should be strengthened to take care of the real estate home buyer cases. This is misfit case, and we are only trying to do a patchwork by way of order of Honorable Supreme Court involving NBCC to come forward and bail out JP or maybe Amrapali, or maybe these kind of things will not work in all cases. Maybe I don't think that there is a solution on these lines. We need to put the things in a right perspective so we have a solution. We are going perhaps in a wrong direction. That is my view. Please, maybe Dipti ma'am has something. If
no, I think you have commented enough. Again, we have time constant, so we have to complete. Already we are running short of time. Yeah, Jasveen, go ahead.
Okay. Reimagining the consideration of resolution plan and the manner of distribution of proceeds from the same during the CIRP process. So there are 5 sets of amendments under this. First is the approval of multiple resolution plan in respect of the same corporate debtor. Right now, we can just have one resolution plan that resolves, buys all the assets and also resolves the corporate debtor. They propose now to enable the committee of creditors to approve one or more resolution plans. However, at least one plan shall provide for insolvency resolution of the corporate debtor as a going concern. Further, they have stated that as and when the COC approves the resolution plan, it can be placed before the adjudicating authority for approval, and the same can be implemented upon post-approval by the adjudicating authority. They have also stated that on approval of the resolution plans in respect of all the assets of the corporate debtor, as well as the insolvency resolution of the corporate debtor as a going concern, only then the CIRP shall be terminated. And the main reason that they had given for the same is it is very difficult to find only one resolution applicant willing to take over all the assets and the corporate debtor in entirety. So this will help in value maximization.
So in one line, I think a good concept to evaluate further. I'm sure government will come out with detailed guidelines and the regulation. Then only we will be able to make further comment. But as a concept, a welcome concept. I'll say yes. We have been facing difficulty in respect of certain large cases where you are not having single prospective resolution applicant for coming forward as a resolution applicant. So good option.
Right. Segregation of resolution plan and distribution of process. The as on date resolution plan itself provides for distribution of process.
Just to interrupt. After 15 minutes, we will complete. What we will do, we will have a second session next time. Okay, because so many slides are there. Okay, so 6:30 we will close.
Sure, ma'am.
Yeah.
So as on date, the resolution plan itself should provide for distribution of proceeds. However, the matter of distribution of proceeds itself was highly litigated, due to which the approval of the plan would be pending. Therefore, they have intended now to propose an amendment for segregating the concept of resolution plan from that of manner of distribution. So they state that the resolution plan should deal only with the inflow of funds and the insolvency resolution, and the scheme of distribution shall be prepared to distribute the funds pursuant to the resolution plans among the stakeholders. Both the resolution plan as well as the scheme of distribution would be required to be approved by the committee of creditors as well as the adjudicating authority. Second, they have gone ahead to state that an equitable scheme of distribution of proceeds would be adopted in case of CIRP as well through a waterfall mechanism. And what they have proposed is that up to the liquidation value, the priority of payment would be as per section 53, which is the waterfall mechanism, and any surplus over that would be divided in the ratio of the unsatisfied claim of each creditor. If there is anything remaining even after that, that would be distributed among the shareholders or the partners of the corporate debtor, as the case may be.
So my inputs, I think as far as the first part is concerned, it's a good option. Only challenge that I can see, well, I'm not able to digest it fully or agree with it fully. To the extent it says that your resolution plan will also provide a waterfall for distribution, right? When it goes on to saying that up to the liquidation value, the priority provided in section 53, for the purpose of CIRP distribution also, you will consider the liquidation value, right? Up to the liquidation value, you will get as per section 53, right? For remaining thing, whatever are being proposed. So there can be situations where the financial creditor finds that his liquidation value is more. So if company goes into liquidation, because he'll be sitting at a, let's say, layer 2, where he'll be only doing a compromise with the workman at a second layer, he'll be getting more value. Why at all he will be proposing or approving a resolution plan? He may be thinking that if I reject the resolution plan and the liquidation happens, in that case, because my value is going to be more, because my liquidation value is more, maybe the CIRP value is less in toto, and I will be getting only part of that in proportion, right? So maybe it is disadvantageous to me. Why at all I will be favoring that? That is the only catch which I am able to see. Otherwise, they have tried to make it equitable, all right, but we'll have to think over, or the regulator has to think over how to avoid such kind of situations also, so that the financial creditor or the committee of creditor does not create any such kind of biases while approving the resolution plan. That's my fear, that when I read the law between the lines, I can envisage such type of situations where such kind of biases can be there while approving the resolution plan.
Sure.
That's my opinion.
Yes, thank you, sir. Moving on, mandating the use of challenge mechanism. They've proposed a mechanism wherein these COC should be mandated to transparently consider competing plans while they are carrying out the approval process or consideration process for the resolution plan. Through an appropriately designed challenge mechanism. This is to avoid delays when the plan is approved by the COC and placed before the adjudicating authority. To avoid litigation during that time, they have introduced, they've proposed this amendment.
I think it's a welcome change.
Right. Monitoring the implementation of the plan. As on date, once the plan is approved, the COC becomes functus officio. However, now they propose to make an amendment into section 30 to state that the committee of creditors may provide for constitution of a monitoring committee to monitor and supervise the implementation of the resolution plan post its approval by the adjudicating authority. This had already been into practice, but now they're giving a more legal shape to the same.
This is okay.
Adjudicating authority to provide an opportunity to cure defects in case of resolution plans. Section 31 as on date states that if the adjudicating authority is not satisfied with the resolution plan confirming with the requirements, then it may reject the plan. However, now they wish to clarify by way of an amendment under section 31 that the adjudicating authority can send back the resolution plan to the committee of creditors for curing defects that are curable in nature. It is just a clarification and it gives an opportunity to the COC to rectify defects.
Yeah, welcome move.
Yeah, this is a welcome move.
This is already being practiced. This is just giving a legal shape to the.
Absolutely. Absolutely. Yes. Reinstating CIRP. There is no legal provision as on date to reinstate CIRP once liquidation order has been passed. There is only a provision to allow sale of the corporate debtor as a going concern during liquidation. However, now they propose to enable the reinstatement of CIRP during the liquidation process if the liquidator carries on the process or the business of the corporate debtor as a going concern. Plus, there is a possibility to revive the corporate debtor in the opinion of the committee of creditors. Further, if the liquidation has been initiated only due to non-implementation of the resolution plan or rejection of resolution plan, then the COC would again be empowered to apply to the adjudicating authority for reinstating the CIRP process wherever it believes that it is beneficial to do so. This is in line with the intention of the code to first try and revive the company as much as it can instead of pushing it into liquidation.
I could not understand much as to what will happen to the timelines if I believe the liquidation order was passed. So 330 days must have already been passed. After that, again, I am saying that we want to explore the possibility of revival. So CIRP will again come in. What will happen to timelines? Are we saying the fresh timeline will start, or they are planning to give another extension to the 330 days timeline? I don't know. still it is not very clear from the paper, at least, unless something more is revealed. It is a mystery to me. I'm not able to understand it fully as to what purpose would be served, though intention may be laudable, but there can always be such kind of debate in every matter that we may make one more try. Somewhere we have to put an end. That is what the purpose of time-bound resolution was.
Right.
So if we are saying that no, again there will be a process which will be again restating the CIRP process during liquidation. What are the reasons? What are the circumstances? What are the timelines in which this will end up? I think after that only I'll be able to comment.
Right.
Right. We have to wait for more clarification, I think.
Yeah.
Yes. Intermingling. Sorry, sir.
So I'm saying ki Dipti ma'am is saying ki we'll have to wait for amendment, but I'm saying by that time it will be implemented.
Ah.
Right.
The amendment will be implemented.
Right. Intermingling the assets of the corporate debtor and the guarantor. So what they propose in this amendment is where the asset of the guarantor are closely and inseparably linked to the asset of the corporate debtor. Such as they've given an example where the building belongs to the corporate debtor, but the land on which it is constructed belongs to the guarantor. So if it is interlinked in that manner, then it is said that such assets of the guarantor shall also be included in the general pool of assets available for CIRP to ensure an effective resolution. Further, they have stated that in case the secured creditors have taken possession of the secured assets of the guarantor, it may have an option to sell the assets through a special window created under the CIRP process.
Yeah, all right. I think interlinked assets have been an issue, but I don't know whether this is a solution which is workable or how it will work out, because it may work both ways. But anyways, we have moved forward at least in a way that law will be enabling, and there will always be possibilities that we can take advantage and disadvantage both ways in certain circumstances. So okay, we will see when more finer details are out.
Right.
I think, Jasveen, we should stop here now.
Sure, ma'am.
And I think we should take maybe in our session after another 15 days as usual. And I think we can conclude here because we maximum half an hour. So Amit, I think I will check with you after 15 days. You are available to continue this. So thanks a lot. Thanks a lot, Amit.
My pleasure.
And just
it was
thanks. Yeah, please, Amit, you are telling.
So I'm saying ki these are mammoth changes, and the government is trying today in one line. If I have to conclude, you were asking in the beginning as to what is your thought on the changes. So my thought, if I can sum up, are that government has done certain laudable amendments which we were proposing from very long time. One thing which government has been missing, I think time and again I have been repeating this to various forum. We met to Mr. Mittal also some time back, and year back when he joined this as a head of the institution also, and previously to Mr. Sahu also. The entire problem of the insolvency ecosystem, although this is an excellent law, I think Dipti ma'am will agree and echo with me, when in 2016 this law was implemented, and till 2018-2019, the biggest advantage was through the change in the behavior of the corporate debtor, through the change in the behavior of a promoter, the change in the behavior of the director or management. Right, that was the biggest change. Now, all of a sudden, there are certain, we are not going into the traces as to what happened, when happened, why happened, but yes, something happened that the law has been diluted for many reasons. B, the result that financial creditor was expecting that a quicker delivery and quicker realization of value, he was not able to do so. When the financial creditor initiated the CIRP process, he was in a hope that though there will be a haircut, but he'll be able to realize the money in a quicker manner. In process, practically, he has seen that the matters on an average had been there before the adjudicating authority for 100 to 120 days. That is the average. Maybe even in many cases, it is more. Even I'm having many cases where the last 4 years, financial creditor cases, Section 7 application has not been admitted. So there are frustrations at the level of the financial creditors also. So point why I am raising all these points, government should have understood as to what are the challenges in the implementation of insolvency, how to reduce these timelines, although the attempt is being made. But I think instead of wasting the energy to the other areas which require less attention, we should have focused only on the areas on which we should have more attention, that is the implementation part. How the success story of behavior science should have been continued. That was the one point. How the timelines should have been reduced so that the interest of the financial creditor, who is the paramount in the entire interest of insolvency, should continue. Number two. Number three, how the mismatch of assets or the information asymmetry should be cured. That is the biggest problem, because I am having 10 mandates today of buying a particular kind of asset. And at the same time, Dipti ma'am is having 10 different kind of assets for sale, but we are not able to meet because there is no common platform. We need a platform kind of shadi.com where you are able to make a match. Unless and until you create that kind of, and that is possible only through the regulator. Maybe I am not capable, Dipti ma'am is not capable, or anyone else is not capable because no one else has a data. No one else has a capability that if I want the minute detail that in Lucknow, I want API unit of size of investment 25 crore, I should be able to search at a click of mouse. The moment it will happen, you will immediately start getting the buyers also. Investors are not a problem. Today, resolutions are not happening not because that nobody is interested. Many people are not knowing. When they come to know, by that time asset is either in liquidation or it has already been scrapped or it has been sold off, right? So mismatch is the biggest problem. I think government should have made the attempt to create the overcoming of this mismatch so that the problem could be sorted. That's my firm view. These three suggestions I still continue with, and I have been vocal on this particular subject with all forums wherever I am there. So I request that regulators should focus only on these while doing the implementation, still, because the law is still in a drafting stage only. So if these are taken care, I think this is a very good law. Insolvency is a base of any business, right? Wherever there is a business, there will be a business risk. So if business risk is there, stress will be there, and stress debusters in form of the insolvency will always be required. So the professionals like insolvency professionals will continuously be there to provide the services, provided the right ecosystem is being created. I think we can do wonders in terms of insolvency resolution. This is just a beginning. We have deviated in between. I think we are taking a corrective recourse. Thank you. Thank you.
Right.
Thank you, Amit. Thanks, Jasveen. And thanks all the participants. And we'll meet again after 15 days. Thanks a lot for the same session to complete. Thanks a lot.
Thank you,
everyone.
Thank you so much.
You have been wonderful.
Thank you.